Yes.
May I please, my lordship? Lordship, this is the subsequent bail application, my lordship. Your lordship earlier bail rejected page number 40 and 41, my lordship. And length of custody today now 129 days, my lordship. Your earlier bail rejected, your lordship has it is written that prayer for pre-arrest bail in respect of the present petitioner Zahirul Islam is rejected. So, my lordship, here it is written there prayer for pre-arrest bail, my lordship, but it was a regular bail, my lordship. Lordship, FIR in page number 23, my lordship, may I read, my lordship, the FIR, my lordship?
This is in respect of...
My lordship, kindly come to item number 2, my lordship, the bail application. Respectful submission, my lordship.
Regular bail one. Yes.
Regular one, my lordship.
Zahirul Islam.
Yes, my lordship. Thank you, my lord. No place. Lordship, this is a subsequent bail application. Your lordship earlier rejected page 41 and 41, 40 and 41, my lordship.
Yes.
As of today, my lordship, length of custody 1 to 9. My lordship, 4 months, 9 days, my lordship. Lordship, FIR in page number 23. Lordship, kindly come page number 23, my lordship.
Okay, so I think after seeing all that we had rejected, so...
My lordship, I am going to argue the case, my lordship, entirely the merits of the case, my lordship. Earlier, there are so many facts, it is not come before your lordship. It is not brought to your attention, lordship. And my lordship, charge sheet have been filed. The most of the charges have been dropped, my lordship. Lordship, kindly hear me for a few minutes. If I can make out the case, your lordship may consider it, my lordship.
Yes, yes.
My lordship, applies, my lordship. My lordship, in the FIR, my lordship, it is said that the initially what happened in the FIR stated that they went to the informant house, my lordship. In complainant house, my lordship. Thereafter, the complainant alleged that they came to my house, trespassed my house, they come to the house, my lordship. And they said that they wanted to say that why they did not come to the marriage ceremony of their nephew, my lordship. Thereafter, there are some altercation happened, my lordship. In that altercation, they have beaten on another, my lordship. And it is mentioned in the FIR is that, my lordship, that their son Hasinur Rahman came in that spot and they beat him with a wooden timber. But, my lordship, in the FIR it is said that the main accused, my lordship, Thanwar Hussain, my lordship. And I am appearing in this case, my lordship, Zahirul Islam. So, my lordship, now kindly your lordship may come to the charge sheet, my lordship. Content in the charge sheet, my lordship, most of the charges are dropped, my lordship. Charge content, my lordship, 38, my lordship. Lordship, initially, my lordship, that particular case was registered at section 61 close bracket 2, which is criminal conspiracy, my lordship. Then 329, my lordship, then on 7. My lordship, kindly, this is important, on 7 close bracket 2, which is grievous act, my lordship. And on 03. My lordship, when the investigation is completed, they have filed a charge sheet. The lordship may kindly see the 17, where it is mentioned that 329 close bracket 4, my lordship, 296 on 5 and on 03, my lordship, on 03, my lordship. Now, my lordship, initially the conspiracy part was there. After investigation, they have said that there is no conspiracy, there is no pre-planned manner, they have done it. Then, my lordship, on 7, which is, my lordship knows, the voluntarily causing grievous act. But here, in the charge sheet, they have mentioned on 5, my lordship, which is causing hurt, voluntarily causing hurt, which is, my lordship, maximum punishment 1 year and bailable, my lordship. And 329 for close bracket 4, my lordship, which is also bailable. Again, my lordship, 296, my lordship, obscene act and song is also bailable, my lordship. Now, my lordship, 103 is involved here, my lordship. And, my lordship, even if it is a case of only causing hurt, which is maximum punishment is 1 year, that means in the FIR, my lordship, they stated that Gurutor Agat, badly injured in that. But after the investigation, the police officers files a charge sheet. In that they says no, it was not grievous hurt, it is only simple hurt, or it is just 1 on 5, my lordship. They have added, my lordship. That means the incident occurred in the informant house, that they have not badly injured. The gravity of the particular offense was not that heinous. Otherwise, they would have taken this 1 on 7 grievous hurt, would have been put in the, my lordship, in the charge sheet. In this charge sheet also, they have put 1 on 5, which is also bailable offense, my lordship. Now, my lordship, if your lordship kindly permit me regarding 103 close bracket 1, my lordship knows that for any offense to commit, my lordship, their manslaughter must be involved there. Here, one party went to another party's house and asking that why they did not come to the marriage ceremony. So, my lordship, your lordship, permit me, may I just state the different side of the history. What is the actual fact? Your Lordship, kindly permit me for 2 minutes. I may make the submission. So what happened? The actual fact of the case, my Lordship, is this, my Lordship, that the informant, the complainant daughter married and eloped with the boy. And in that marriage ceremony, my Lordship, the particular accused petitioner, who is the uncle, my Lordship, the Lordship knows that this present petitioner and the complainant own brother, my relation. And they have invited their niece, my Lordship. When they invited their niece to the marriage ceremony, this particular informant come and ask him, why did you inform my daughter? Why did you invite my daughter? Then he said, my Lordship, that he is also my daughter also. Just because he eloped and it has been long time. She can come thereafter, and that there are some dispute happened regarding why they have invited to their house, my Lordship. After that particular thing, altercation happened, my Lordship. In that altercation, my Lordship, both parties became on another, my Lordship. And my Lordship, in the FIR, I have read out, there is a missing part gap there. That means some of the history they have picked up, cherry picked, my Lordship. That means the entire history is this, they have fight on another, my Lordship. And in a defense, my Lordship, in heat of the moment, the accused number 1, I am the accused number 4, my Lordship, in the bail application, my Lordship. The accused number man with a wooden timber hit, that is in the FIR allegation. And in the FIR it says they badly injured. But 117, which is the grievous act, which is absent, my Lordship, in the charge sheet, my Lordship. That means that particular charge 117 is dropped, my Lordship. And then, my Lordship, the particular the disease victim died after 5 days, my Lordship, in the hospital, my Lordship. It is not my case, my Lordship. I am not saying that it can be conclusively can be said that because of that 115, which is the bailable offence, my Lordship, and it is a simple heart, my Lordship. Only in simple heart people cannot die, my Lordship. That is not my case. But what my case is this, my Lordship, with the profound respect and respectful submission, is this, my Lordship, that particular entire thing happened in arose in a particular circumstance happened. So it is entirely circumstantial. And 61 criminal conspiracy pre-planned manner, that also been dropped in the charge sheet, my Lordship. So that thing happened, my Lordship, the tragic and unfortunate incident occurred in a circumstantial basis, my Lordship. Lordship may note this thing. And the second thing is that, my Lordship, that they are saying that they have beaten on another. But the missing part in the affair is this, that the prosecution side, sorry, my Lordship, the informant side, the complainant side, and the present accused petitioner, my Lordship, that there are a good term before that, my Lordship. Because of that particular thing, they have initially argued and they differ on another, then things happen. That is second thing. And my second limb of argument, I'll make it very short, my Lordship. The most of the allegation in the earlier, whatever the charge was dropped, my Lordship. And 103 regarding, I would just like to say only one sentence with due profound respect, my Lordship, that in this case, the part of mens rea may be missing, my Lordship, may be doubtful, my Lordship. And as far as my Lordship, other section already been dropped. And charge sheet, all sections are bailable, my Lordship, except 103, my Lordship. And I am being in the custody for, my Lordship, 1 to 9, 4 months, 9 days, my Lordship. So my humble, respectful submission that further custody, my Lordship, in the judicial custody, my Lordship, with due respect, may not be required, my Lordship. And the circumstances that particular thing happens, my Lordship, your Lordship may give me the benefit of doubt of, my Lordship, the mens rea, my Lordship. That is, my Lordship. And, my Lordship, I would like to just humbly say that, my Lordship, that I have a daughter, I have a family, my Lordship. I will completely with the cooperate with my Lordship, the trial proceeding, my Lordship. I will not hamper and temper any witness also. I am not in a position to fling the country also, my Lordship. And I am not in a position to hamper and temper the evidence. I am not an influential person in society, my Lordship. I am very decent family, belongs to a very decent family, a very poor family. I am not in a position to administrating this thing, my Lordship. So, Lordship, my respectful humble submission, considering the facts, considering the charge dropped, my Lordship, and considering the length of custody, my Lordship, may I humbly pray for my Lordship, enlarge on me bail, my Lordship. That is my respectful submission. Everything is under Lordship consideration, my Lordship.
Yes, PP.
My Lord, here it is not the case of, my Lord, simple injury, grievous injury, my Lord. Here one person died, my Lord, where it was, my Lord, brutally assaulted and killed, my Lord, disease, my Lord. Lordship, may kindly produce the PM report, my Lord. Several injuries are there, my Lord. And from the witnesses, my Lord, it reveals that, my Lord, the present two petitioners, both father and son, my Lord, both have brutally assaulted the disease, my Lord, and for which he has succumbed in the hospital, my Lord. And in the Lordship order, my Lord, it was rejected only on 27/7/26. After filing the charge sheet, Scan copy was called for, and after going to the TCR, my lord, Lordship was pleased to reject the petition, my lord. Here is no new grounds at present, my lord, and only length of detention is not consideration in such type of heinous offence, my lord. How brutally he has assaulted, my lord. Kindly the PM report, my lord. And other witnesses, my lord, 183 statement, my lord, several witnesses are there, my lord, 183, all of them implicated, 180 statement, my lord, all of them implicated, my lord, and eyewitnesses, all of them, my lord. In the
See, let us do one thing. Since scanned copy will be available with the earlier case, which was rejected at the principal seat, we'll have this next week and list it along with the earlier bail application where the scanned copy will be available. Then we'll be in a better position to appreciate his arguments.
Madam.
All right. Heard learned counsel for the petitioner, learned additional PP. This is the second bail. This is a application for regular bail in respect of the present petitioner. Full stop. His previous application for pre-arrest bail was rejected by order dated
27/7.
That was also regular bail, wasn't it? Earlier pre-arrest was rejected. Huh?
It is written the pre-arrest.
Although it is rejected,
But the paper for pre-arrest bail get rejected. Military concern here, my lord. It is regular bail, my lord.
No, this order you have annex 27/7. That is a bail application, not pre-arrest. I think what is wrongly put as pre-arrest. That was I got a little confused. Yes, the earlier bail application in respect of the petitioner was rejected by order dated 27/7/26 in bail application 1620 of 2026 after perusal of the scanned copy of the TCR. Full stop. Since the scanned copy is already available with the records of the said bail application, list this matter along with bail application number 1620 of 2026 on
My lordship, next week, my lordship, any date your lordship clear.
all right, Wednesday.
Okay.